Now, this is issued by the Principal Secretary to the Government of West Bengal, School Education Department. The heading of this or the preamble is the undermentioned case of the School Education Department, along with a spare set of papers, is forwarded for placing in the next meeting of cabinet discussion. Right?
But if the cabinet agenda prepared by the principal secretary as per the books of business,
now this has been noted as cabinet memo. This is subject discussion. It is a proposal for creation of supernumerary post of assistant teacher, including physical education, work education, non-teaching staff in such and such, for accommodating waitlisted candidates. Salient facts. Facts are not relevant. Now, grievance of the recruitment, such and such, such and such. Now, one after another proposal is coming from the stakeholders. First of all, it is coming from Central School Service Commission. Now, what it is saying that 5261 posts are required to be created. This is the proposal of the Central School Service Commission. Then second part, there are two parts. The second paragraph, it proposes cancellation of some appointment letters. You come to the next page, before the proposal of the Commissioner of School Education starts.
The item 2, if I mean the expression, proposed of Central School Service Commission and Commissioner of School Education.
No, before that, the last line, the West Bengal
Board Department considered
No, II.
Yes.
Because paragraph 2 contains the proposals of the Commission.
Yes.
First proposal, creation of 5261.
Yes.
And the next paragraph starts with the chairman.
Yes.
Then it ends who do not feature in the list or in the wait list, the West Bengal Board of Secondary Education may cancel appointment letter directly. These are the two proposals came from School Service Commission. So, they said that 5261 posts are required to be created. What would be the nature of post? How created? Why created? This has not been explained.
No, they say it's for accommodating waitlisted candidates.
But whether it will be a supernumerary post.
This I have answered, I informed it by the square. Therefore, they say that these waitlisted candidates, they were waitlisted because of declared vacancy. Therefore, they had participated in the declared vacancy following these equipment rules, where they could not be accommodated because they were not found to be within the cut-off region of merit listing. So, waitlisted candidates' validity is only for the purpose of.
No, I understand. They could not be accommodated because either they are below the cut-off mark, and by the time the post vacancies have been filled up fully.
Therefore, they were agitating now the School Service Commission.
Now, this is the proposal of the Commission as it appears, is for creation of the post. What would be the name, nature? They have not suggested.
They want, we want to get this amount of posts.
Mr. Dr. Patro, this is there.
Yes.
The 5261 posts are required to be created. Two suggestions came from their end. They found some cases where either panel or waitlist should be cancelled, whatever. Ultimately, board may be approached for cancellation of the appointment letters. So recommendation by the time had matured to the stage of appointment. The second part we are not concerned, but the creation of post suggested by the school service commission. Now the preview comes to that next, that 5261. This is with reference to 11th group C. Subject to correction. May I just read it? This is not with regard to. But that is, thank you. Thank you. I want to know where is your suggestion or proposal for creation of vacancy for the work education? That is the next page. Kindly come to me. Yes, please come. The first paragraph after the first three lines. This is not your proposal. This is the proposal of the commissioner. No, very well. Dr. Patro, please, you have got copy. Please find out anywhere you have suggested creation of vacancy to accommodate the waitlisted work education, physical education teachers of first SLST 26. This is number one query. See, the second query of mine is the Commissioner of School Education. I think state can explain this situation. This is a suggestion from the Commissioner of School Education. It's very direct. He's saying for absorption of these teachers, create this post, work education, physical education. Now, department's view is coming thereafter, legal view, views of the Advocate General, Finance Department. Mr. Bhattacharya, please apprise this code. Last line. As discussed of that page, views of the Finance Department.
As discussed and in consideration of observations of law department and views and advice of the Advocate General, which appear to be in conformity with the proposal of School Education Department. Therefore, the proposal of School Education Department was approved by the Advocate General. We may have no objection to the proposal as contained in the paragraph 3 and 3.
Let us see what is 3A and 3B. This is 3A, creation of filling up this one. 3B.
3B is below the state absorption of below 3.
No, first of all, this is absorption of the waitlisted candidate.
Absorption.
But B, what the B is saying, I am on B. I want to know from you about B. Now, subject to proposal as contained in 3A and 3B of the memorandum for the cabinet, this is subject to the approval of the cabinet and adherence to the extant rules. Now, Mr. Bandyopadhyay, this is, if you please, all of you concentrate on this. If you come to the last line, however, the same shall be subject to the outcome of pending cases before that. Sorry, absorbance has the witnesses candidate in the proposed summary to be created with the approval of the cabinet. Can you show the approval of the cabinet?
So it was placed before your cabinet note. Cabinet note was placed before your
Cabinet note. Are you sure the approval was?
Yes.
There was an approval? Huh?
Yes.
Because in supplementary affidavit, what I got.
I got it because if your lordship sees the memo, impugn memo of your lordship, 19th May. The second page starts that the cabinet has been pleased to take the decision on the 22nd meeting on 5th May and accorded approval.
No, I have forgotten firstly. I am sure the approval of the cabinet was there.
5th of May.
5th of?
May I hand over my copy of
what is that? Impugn notice?
My opposition.
Impugn notice. Impugn notice is there.
For your lordship's convenience so that your lordship need not. First, page 48 or 49. First line. Can you see the first line of that page?
First line has been pleased to take it 22nd meeting 5th May. Why? I'm telling you. On 5th May, this cabinet memorandum was generated on 5th May. And 5th May accorded approval. Is there no confusion that memorandum was taken to be as an approval or a separate approval is necessary?
Memorandum, well, this is of 19th of May.
No. Please come to the memorandum dated 5th May 2022. Though accorded approval filed memorandum date number 276 is not matching. So it can be presumed that cabinet has approved. Presumption is there, the cabinet has approved the decision, right? Now, if you come to 3B, finance accorded rather permission as contained in 3A and 3B. Now, 3B talks about state government may permitted to issue necessary direction to the commission by invoking section 19. Dr. Patrov, did you receive any direction from the state in terms of section 19 to create such vacancies? Because it is moving in a way. 5th May, there was a cabinet memorandum. 5th May, approval was accorded as it appears from the order itself. Then 5th May, when it is asked that 19 under section 19 direction be passed upon the commission, when it was done, whether the notice was under section 19. Please show him the. Please show him. Invoking section 19, issue necessary direction. I want to see the direction which you received under section 19, reacted, declared the vacancy on 19th. Now, Board of Secondary Education was also directed. West Bengal Board of in interest of education in terms of 3.2. So there were two directions were contemplated under the memorandum. One under section 19, another under section 3.2 of the rule 3.2 of the 2018 rules. Dr. Pacho, can you take instruction whether 19 direction you have ever received or not? Secondly, I think that we are at the flag and we cannot delay the matter. So I will be expecting today you can get this instruction. Right. And what about the board? I need to know the board's stand. Anyone from board? Mr. Dasgupta inform Mrs. Bhattacharya. Because these two directions are necessary because finance conference was given subject to compliance of these two directions.
Just to add, this is subject to approval of the cabinet and adherence to the extent rules. That's very important. That's what
whose obligation is to? Whose obligation to see that whether extent rules?
School Service Commission is under the law, the selecting authority, and on its recommendation, board is appointing authority. Therefore, the observance of extent rules would well be there upon the School Service Commission and the board.
So I want
And
to have
that
this.
this is for absorption. I have already done it on the matter in detail.
That you need not repeat it. First of all, let me understand these two things. Because section 19 and
And section 19 that I had submitted, I was only reiterate section 19.
This commission 97 Act.
But section 19 does not authorize the government to directly Civil Service Commission to create supernumerary posts or to appoint only the agitating people. Section 19. I am reading on. In discharge of his function,
Just এই কি হলো কি বইটা কোথায় গেল?
come to section 19.
No, not. My next query would be on two notifications. One of 20th September 2016, whereby 2016 rules was framed, and secondly, the notification by which the commission, actually it is a recruitment notice, dated 16 December 2016. Right? These are the two notifications on which I have some queries from.
2016.
And please keep it with you. I'll be coming back. 20th September 2016. That is framing of 2016 rules.
Into that, discharge of the obligation of regulating power by the state. 20th September 2016 notification. That's a part of the petition.
Part of the plan. Very well. Just make it available for you.
Page 248.
Yes, my next question will come on that. Now, section 19
Section 19. Yes.
and also 3.2 of the 2018 rules of the board. 3.2. Now,
section 19. Section 19 will not read this. Very important. At this time, direction by the taker in the discharge of his function. The commission shall be guided by such directions as may be given to it by the state government from time to time in conformity with the provisions of this act. State government will, like an ombudsman, will ensure that the commission does not travel beyond that. That's why you can issue direction. No, this step is not right, you follow it. But section 19 also does not empower the state to give any such direction which goes against it.
now that is exactly what I want to know. Now, assuming though Dr. Patra has to show me that such direction was made, because the time frame is very peculiar. 5th May
On the very same day.
The cabinet memorandum, 5th May cabinet decision, 19th May the notice. Therefore, finance is according no objection subject to 3B.
And following extent rules.
Yes. Now 3B, if there must be a direction upon the commission and upon the board under 3.2 before publication of this. That I want.
Only one thing, 3B, this section 19, this is for the purpose of adoption, not for the purpose of creating a supernumerary post. The notice on the section 19 will come.
No, whatever.
No, I'm making it clear because my learned friend is.
No. Perfect. I want a direction came to you in terms of this cabinet memorandum. Just tell me if you and bring that direction. Now section 19, there is appears to be a caveat. What is that? In conformity with the provision of this act. Now, creation of this post where the state government is compromising with the provision of this act.
Yes.
Where?
Because by virtue of this act was the 2016 rules was straight. 2016 rule is in the creation of state.
Let's show me that power making, rule making power.
Because the rule making power is
97. Mr. What did I do? I'm coming back. Just arrange of your, because you are not aware of the queries which will be coming to you. But the commission has been set up for conducting the selection process, and the rules are there formulating or specifying
the method
of appointment of teachers
and also the identifying vacancies.
All complete mechanism.
Yes.
Complete mechanism. Now tell me the framing of rules by the commission.
No, rules by the state.
Sorry, by the state. Rules by the state is
Section 17 empowers. I'm just here before the issue rises. The state government may by notification make rules.
precisely D.
Yes.
Precisely D. Manner and scope of selection of persons are appointed to the post of teachers under subsection 1 of section 8.
Section 8.
Manner and scope of selection of person and procedure for conduct of business of commission.
No, the manner and scope of selection of person for appointment to the post of teacher shall be as such as may be prescribed. This prescription comes from the making to 16 rules. The procedure for the conduct of business of the commission shall be such as may be provided by the
So, manner and scope of selection of person for appointment to the post of shall be such as may be prescribed. It talks about the rule. Then commission, how it will be conducted by a resolution. Now, if 8.1 is parcel of this power, rule making power, restricts the rule making power, any direction which offends, if in a very if I say it very casual manner, even, that a direction came. No, you need not follow the 2016 rules.
Yeah.
You do it in that way. Whether such direction the commission is obliged to follow. Please answer this. And what was the commission's role in advising the government or suggesting the government that here the shoe pinches,
Commission is good.
that this we can.
I had argued with the commission may not exhaust its power as soon as the notified vacancies are filled up. Till fresh vacancies are declared for fresh process. Commission was created by a statute to ensure that the recruitment.
So, anyone please show me, Mr. Bandyopadhyay, a direction came from the school education department. Suppose
19 minutes, second last.
no, direction to. If you see the cabinet memo 3B, it refers to about a direction under section 19 by the government to the commission. I'm directing the commission to produce that direction for cross-checking. You inquire whether such direction was made between 5th May or prior to 5th May and 19th May. And 3B talks about a direction under Rule 3.2 of the 2018 rules. Have you ever received any direction from the state as under 3.2? So far with regard to the creation of this post, time limit I am telling you, it must be within 5th May to 19th May. Please inquire. It cannot be deferred. I have to know it by today. It is, I want to know answer yes or no. All of you coming for 5 minutes, please. Section 19. The direction comes from state on the government offends any of the provisions of the act, then either commission may not follow such direction.
Under the proper exercise of legal authority.
May not. But reality is that they are bound to. Reality is that if that direction is challenged and it will be shown that this is not in conformity with the act, then the direction can be declared to be void direction. Therefore, according to you, 19 vis-a-vis the power under section 17D to frame rules. So, any direction which leads to compromising to the service, rather the recruitment process or the rules, that is a bad direction.
And that's why because the results requirement or
Yes.
Instructed no such order which
No such direction under 3 the board ever received.
not in this regarding this.
Supernumerary. Have you taken that answer?
I have taken, I had a discussion with the chairman, could not say, because today our results are coming out to you. Said that he requires a day or two. But what my learned friend is saying, or what we are searching for, that is actually mentioned in the order dated 19/05/2020. My learned friend was pointing out, Mr. Bondabadhar, that here the directions are there. If I not see the second page,
No, 19th May, it is your declaration in 19th May.
no, the order comes with the direction. That is what we are trying to do. The petition page 300.
P2, there is no direction.
Well, may I come back?
Both directions.
May I come back?
Both directions are there in the second page of the.
Second page, that is 301. From top folders. Now, therefore, in exercise of the power conferred under section 19.
Dr. Patro,
was the creation of the
Yes, and kindly see the
no, Dr. Patro,
minor.
section 19 direction would come to you. You are the recommending authority. You are neither can create a post nor can actually declare the vacancy independent without following the 8 procedure under rule 8. Now the situation has become something more is complicated because the board has intervened to authority to determine the vacancy. When this selection process was going on, the process was this. Now, what was the cabinet memorandum? Cabinet memorandum actually finance granted the no objection subject to compliance of 3B precisely.
Yes.
Therefore, it presupposes a direction. What direction would come to you? The direction possible that recommend supernumerary posts are created, recommend waitlisted candidate against this supernumerary post, as I understand. But does it this 19 is
Yes, and
reflecting
see,
so?
that is also is, uh,
Well, may I only add one line? But the cabinet memo does not make it a precondition for approval. Kindly speak the language of.
No, not that.
It is subject to, not a precondition.
Subject to means
Subject to means that finance is giving approval. subject to the fact that state government will issue the direction under section 19 of the Act and 3(2) of the rules of
What kind of
2018.
direction?
But what are the precondition?
Very well, at any point of time.
Why I say this, Lord, and apropos to the question which fell from your lordship, sir, that whether there was similar direction between 5th and 19th. So, Lord, from that question which is falling from your lordship, Lord, I am of the understanding that your lordship is treating it as a prima facie, as a precondition.
Very well, let us not go by that.
But it is not
Even if it may come, such direction must come with the notice,
with the approval.
or with the notice, impugn notice,
Then-
or even thereafter.
I request your lordship to, along with the finance note, kindly read point number 6, which was the note placed before the cabinet for approval. That
Yes, yes,
that is
yes.
exactly
I am now
reproduced
only-
in page 300.
I am now on the finance. The finance gave no, unless post creation, appointment, all will depend upon the finance.
Not when from your lordship, Lord, it presupposes.
Yes.
Meaning, Lord, it's not a precondition.
No.
It is
Before you engage somebody, you must have a money in your pocket. Unless finance gives you that signal that yes, you can
and
engage.
giving the signal by saying that I will.
No, I'm to get it.
Once you issue a direction under section
Understood.
19 and 3.
Understood. Now, excessive power conferred under section 19 of the West Bengal School Service until the governor has been pleased to create. I am unable to reconcile with direction of the section 19 and creation of the post. They are not the persons to, commission is not to create the post. 19 direction, as it can at best happen, that we have created this post. And because you have very consciously, you did not say that create a supernumerary. You have said create post to accommodate this kind of persons. Now the impugn memo which you have issued, rather government has issued, what by which a creation of some post. Now 19 direction is issue recommendation of this that as you have rightly said, for the creation, it is your evidence. We have nothing to do with the creation. We are only recommending body. We are here to recommend. So direction under section 19 must be in conformity with your power to be exercised. Please read this 9.
May I place it because it is not missing, it is there. First I am reading from the cabinet memo. What was written there? Permission to the state government in the Department of School Education Department to issue necessary direction to the commission by invoking section 19 of so and so, and in the interest of education in terms of P2 of the courts for absorption, not for creation of supernumerary. The word absorption is being used in the memo. Now the same word is being used in the order which was passed
on 19.
Yes, now kindly let me read from the.
We are not on this
Keep
point.
it order.
Yes, Dr. Patro, I want to know the nature of direction which you can be.
Yes, that is stated here. Let me
Yes,
read
that let us see. This is the only place where we are
Yes,
can
so-
get the
So
19.
the word absorption used in the government memo that you are to issue the rule. I'm forgetting about the board for the time. You are to issue a notice under rule under section 19 for absorption. That is the memo, the cabinet memo. Now kindly see the impugned order, page 301. What language has been used there?
The problem, try to address the problem. The direction governor has been pleased to create supernumerary and non-teaching staffs for absorption. Where is your role here?
The absorption part is our rule.
For-
This is what was the language of the cabinet memo? The cabinet memo was that rule under section 19, notice will go to the commission for taking steps for absorbing the
Please,
candidate.
Dr. Pato,
Now let's read.
section 19. Please read. Now, therefore, please see.
Yes.
In exercise of power conferred under section 19 West Bengal such Act, Governor has been pleased to create this. Section 19 is a provision to create.
Yes. No.
It is not
It is not. But it is followed by the following part of
yes, create.
or absorption.
For example, no doubt.
So that is their function. Commission's function is post which has been created by the governor or with the
So,
permission of the governor.
Dr. Pato, in which way you may read it, but section 19E contemplates the power, reservation of the power in the hands of the state to make you some directions.
Yes.
Direction apropos to your function. Your function is to recommend the candidates against the vacancies. Now a vacancy has been created by the state. The state thought that the waitlisted candidate should be absorbed in those posts.
Yes.
Now your role is only to recommend.
Yes.
19 recommendation, 19 power, state by exercising such 19 power can only direct you that recommend appointment of this persons for absorption. That is not I am getting.
But that is not clearly mentioned, but it is clear from this paragraph.
According to
that
you,
we are to
it can
absorb.
be gathered from the intention.
Not only that, kindly read the bottom portion, copy forwarded to the chairman West Bengal School Service Commission. There the government has given its note that we are to, with a request to provide detailed category-wise list of such waitlisted candidates with the Commissioner of School Education. This has a reference to the office letter dated so and so. So the fact that we have been directed to absorb for that purpose.
Now, now 3.2, the next part, seemingly clear.
No,
In exercise of power under Rule 3.2 of the such and such Rule 20, further pleased to direct that appointment letter to such waitlisted candidate should be issued.
in the terms
This
of the
is in
recommendation.
conformity with 3.2.
Yes, in the terms of the recommendation.
Now, of course, 3.2, it is very clear.
Yes.
It is inbuilt
Yes.
that governor has been pleased to direct the purpose of the board is to issue appointment letter.
That is because their role is just.
But 19 is very cumbersome. Very cumbersome way.
I cannot change the language.
Yes,
But
yes.
stuff is there. That it is clear from the language.
In the later
That
and
it
speed,
should be
in
detailed.
later and speed, rather a section 19 direction is inbuilt according to you, inbuilt in the impugned knowledge.
Yes. Yes.
It cannot be said that it is lacking, right?
Fine.
Now, Mr. Bhattacharya, next question of mine regarding these two notifications. So these are the, which one is the product of the section 70 of the 97? Which one of these two?
So kindly come to the section. Section
Yes, 17D, manner and scope of selection persons.
that is prescribed. What is the prescription? It's 2016.
This is 2016 rules.
And this prescribes kindly down to the 2016. Here, pilot will find how the vacancies are to be.
Yes, I have gone through. You have put on length.
And then, therefore, every action, unfortunately, on the strength of cabinet decision is purely law. That was the first condition which I had tried to develop. And
How do
cabinet was very much conscious.
that you have
Always extend rules. Extend rules.
always. Even the finance was very
Very clear.
conscious about that, but actually the commission I should have there should be much clarity on the part of the commission in the cabinet discussion. Now, if you come to 16, rule 16.
Yes. Rule 16 of 2016 rules.
Hmm.
That
If you come to first proviso,
yes.
it is talks about the expiry of patent. First proviso.
Provided the names of candidates shall not be recommended against any post other than the post applied for.
First of all, forget that. Against any vacancy which has not
Must
been
be
notified.
notified in terms of subjectivity of the lay.
Does it mean that a vacancy which has not been declared
Cannot be avoided.
83 B. 83B means 83 one rather specifies the time limit. First at the time of advertisement, a final list at the time 15 days
Before
B. Emphasis on B, the final list. Shall know against any vacancy which has not been notified.
prohibition.
Right? So 3B says that this is the time limit to up to that time the commission can ascertain whatever the procedure commission is, the procedure prescribed under Rule 8. It is a procedure to be exercised till such time. Against those vacancies, the candidate's appointment can. Beyond that, it is not possible.
That settled law have cited authority also.
Right? Now, if that be so, is there the commission? Is it not the duty of the commission to bring this position to the knowledge of the legislature or the cabinet?
And that's why the document is to notice that the commission did not recommend for this work education physical. That was recommended by the Commission of Education, that's the education department.
The commission only suggested creation of vacancy.
For 9, 10, 11, 12 group CD. There are 2 parts.
Yes, this is another important thing. For work education, physical education, commission never suggested creation of
Commissioner of School Education. Therefore, the state on its own completely denying the procedures, keeping the commission of school education into dark. This Commissioner of School Education, page 2, detailed proposal dated 4th of May. 5th of May is the cabinet memo. Commissioner of Education is creating the proposal on 4th of May. But another aspect, such a hasty thing with all
that is what hastily done. Now, just telling you, if that commission did not make any, it did not propose to create supernumerary post or any post, any vacancy for absorption of this.
work education physical.
What is the effect?
But effect is that the commission, without under the authority of law, did not feel it at all necessary. If your lordship can see language, commission will not felt that for 9, 10, 11, 12 group security it can be done. Created of. And why they have filed subsequent applications on record that we want to accommodate the illegal appointment. That was also record which has been taken note of by the Honorable High Court and Supreme Court. But the vocational education, physical education, it is without the Commissioner of School Education. Madam, can you take the trouble? I am sure if I am not wrong, if I am wrong, I should be corrected.
Yes, he's the commissioner.
Yes,
Not the
not the school service.
schools commission only
Enter
says this much of.
Paragraph 2, proposal.
Correct, Dr. Patro?
Proposal of Central School Service Commission, Commission of School Education. Central School Service Commission recommended for teachers 11, 12 and so on.
No, I have deviated from your own reply, but the last question, last one. Take the 16 December 2016 notification of the commission. This is employment. Please take that.
Yes. 16 December. 16 December, September. Without wasting my lord's time, it will also kind of exclude.
Last three lines marked somewhere. You please see the last first paragraph, last three lines.
This is 16th December.
Employment.
Yes. I'm just giving out.
Recruitment.
The West Bengal School Service Commission has been designated to conduct state level selection tests for recruitment of assistant teachers in physical education, work education in recognized non-government aided sponsored school West Bengal against the vacancy.
Again,
Please. Under the West Bengal School Service Commission for appointment of recruitment in school service. That's your power.
so recruitment notification was clear that the only those vacancies which could be ascertained in terms of the first SLSC 2016 rules.
That's true. Good. That was the basic argument. You have declared vacancies, you have undertaken recruitment process.
Failure.
Somebody which I was interesting, just to remind the Lord, I don't take much time. State in its affidavit that said that the waiting list is automatically extended. I've never heard of this theory. Rule says the wait list does not exist after 1 year. The cabinet decision is taken after almost 3 years. I have all mentioned, just refreshing my memory and with my memory. And in the affidavit, the education department says that they automatically extend. Still, the matters are pending before the significant proposition. Anyway, that was not also supported by any council by me. And this was my specific argument that there cannot be automatic extension of waiting list candidate. And the waiting list cannot be a permanent reserve of appointment of future vacancies.
This is setting. This is settled law.
Settled law. No, I have not argued anything which is not yet to be settled by.
Now, give me answer on the judgment passed by this court last occasion. Another order, not the judgment, order passed by this court, which our judgment justice.
Your judgment.
Yes.
I've seen that.
The Advocate General last occasion aside.
That was
There are others also, more than one. But I have not brought the one.
No, since it has been cited, I have to put.
I need to share with you order that.
মাল করে দাও না
I will read out loud just to make the clouds not to be clear. The petitioner participated. So this was the 8th of February 2024 in the first SLST selection 2016 for recruitment in the post of assistant teacher in subject work education, physical education. Under the category OBCP, petitioner is praying for a direction upon the West Bengal School Service Commission to disclose his result say test. Dr. Patel on a counsel for the commission submits that the panel of the selected candidate expired long back on December 11, 2019. And the present petition since has been filed long 5 years after the expiry of the said panel is liable to be dismissed on the grounds of the petition alone. Therefore, Dr. Patel's stand is that the waitlist does not exist. The panel since has already expired long back. No fruitful result will be served by directing commission to disclose the result. Therefore, that again reaffirms my submission.
So in my affidavit also I have stated it expired. I have
Therefore,
stated it did not.
but
Possibly, Mr. Advocate, you want to take me to the principle of doctrine of res judicata.
res judicata will not between the contesting parties, not for third.
Now that I have, Mr. Bhattacharya, I have already had in a civil second appeal. At res judicata is a doctrine. If section 11 may not be exhausted, relied on a very old Privy Council. It is a theory. If ultimately it is found The test is
Law is settled.
issue decided.
Yes, law is settled. Then you know that would apply as we were taking law of precedence.
Section 11 is an illustrative.
Without
It
the
is
law
not
of
exhaustive.
precedence. But our the Supreme Court judges also without that someone who was not part of the primary petition can finally petition challenging.
Yes, I don't know that Supreme Court judgment,
Yes.
but the facts of the case was,
Doesn't matter. Yes.
facts of the case was, a person was, a lady claims to be the married wife of the person, claims the inheritance of the property. The wife, actual wife, she thought that and found her case was that I am the owner. This was contested. The second wife lost. Then at the execution stage, the son allegedly begotten with the second wife by that man came and took out an application in execution. The decree is not binding. Then the issue came. I was not a party over there. I had the occasion to deal with
Yes,
that.
yes, property right.
Yes, that I raised an issue. Principle of res judicata. Your claim, you are challenging that your mother was the heir, which has been negated by a court. You cannot reopen that issue. Then he took a point that I was not a party to that. Therefore, that I have detailed in that it is not the test of section 11 alone. It is not exhaustive. It is illustrative. It is a doctrine. In fact, if it is found that court will unnecessarily re-adjudicate the issue, but I don't think there is an issue decided.
My lord was deciding the property right, the common law.
No, it is not an issue decided
Yes,
here.
not-
Particularly,
And
no,
it's the constitutional right.
so that's all.
Can I just add one point? The mention of the accordance with the extent of the cabinet. That if we read the entire cabinet memo, it is suggesting the absorption or the filling up of the candidates, leftover candidates, from our waiting list, fill them up in the supernumerary post. So as per the extent laws built from that state, what law governs me from that state? That is the
Dr.
recommendation.
Patro, you never
Calling for counseling, recommending, taking the declaration, sending their names to the court. That is the
you never gave the proposal for creation of any post for the to accommodate domestic candidate.
Dr. Patru is they have taken another step. If I am not wrong, that this is for the particular section of the people, therefore rules doesn't apply.
Yes, yes. No, that what Dr. Patro is saying that is a substantive post.
candidate in a particular
Recruitment
position.
The recruitment will
It has nothing to do with it.
recruitment procedure guided by the statute. It was taking.
Eh,
So the question is,
notification on the 19th
Yes.
on that issue. No, no, no.